Good afternoon and welcome to today's edition of Facebook Live. My name is Mason Waring and I'm a partner in Chisholm and Kilpatrick's insurance litigation practice. With me today is Leah Small, who's an attorney in the practice. And today we're going to talk to you about definitions of disability that you'll find in long-term disability policies that you would have bought yourself from the insurance company or that under which you would have been covered through your employer. Many people whose long-term disability claims are denied, they're denied because, or the insurance company says they do not meet the policy's definition of disability. And so we're frequently asked, well, what does that mean? Because we can't do our job, we can't do the work we did before, and the insurance company is saying that I can do another job. And a lot of people are confused because they think that if they can't do their own job, they should be getting benefits. It's often not true, or sometimes it's true for a small period of time, but then after 12 or 24 months, the definition of disability changes. So we thought it'd be good today to talk about some of the basic concepts relative to definitions of disability, and hopefully you find some of these tips helpful. So we're going to start out by talking about why definitions of disability are important. So Leah, could you tell our viewers?
Sure. So the definition of disability is essentially the core of your LTD policy, and it's usually a good place to start in order to understand what kind of LTD coverage you have. And it helps in a few different ways. One, it helps you understand what kind of protection your policy affords you. And it also helps you know what kind of evidence you're going to need to provide to the insurance company once you know what you'll need to prove in order to be eligible for benefits. And the third way is how to communicate with your doctor. So once you understand what the definition of disability is and what you need to prove to show you meet that definition, that can help you talk to your doctor and work with them in filing your claim. A lot of times, like Mason mentioned, that claims will be denied because the insurance company is saying you don't meet the definition of disability. So it's important for you to go look at that definition and read it so you can try and understand the position they're taking. But honestly, if you're handling your LTD claim on your own, you shouldn't just read the definition of disability. You should be reading your policy from cover to cover because there's a lot of important information in there.
Yep. And there's two main types of definitions of disability. Could you explain the difference?
Sure. So wording will vary from policy to policy, insurance company to insurance company, but usually you'll find the own occupation of definition of disability and the any occupation definition of disability. Sometimes called regular job, regular occupation, but those are kind of the two broad categories. Typically in a policy that has the dual definition, it's typically own occupation definition for a period of time, 12 months, 24 months, 36 months, and then it often switches to the any occupation definition after that time period is over.
And in our practice, we spend a lot of time representing people whose long-term disability claims have been wrongly denied, right?
Yes.
And so people contact us. They've been on claim for a period of time. They get a denial letter, and it says, while we understand you can't do the work you did before, you can do something else, right? And that's often around that 24-month. I think most of the denials we see, it's at 24 months, and I think many policies they have the 24-month own occupation period, and then after that it goes to any occupation. So let's dive a bit deeper. First of all, if anybody has questions, just send it to us in the comments, and we'll do our best to answer that. And don't forget to like us on Facebook so you can hear about our future presentations. So let's get back to it and dive deeper into own occupation. Can you tell us a little bit more about that? Yeah.
Sure. So generally, the own occupation definition of disability asks whether you're able to perform the material duties of your own occupation, which is usually the job you were performing when you became disabled. So there are a couple different parts to that. Like I said, the material duties that are often referenced in these definitions. A good place to start, those are what went into your job. What did you have to do on a daily basis to perform your job? Oftentimes, your policy will define what they consider to be the material duties generally, but you can also one thing to keep in mind when they talk about your own occupation, they're not talking about your specific job, typically as it was performed for your specific employer. They're talking about your occupation in the national economy. And what that means is it's kind of on average how that job is performed across the country and what kind of duties are needed to perform that job.
And some policies do define disability or look at the material duties of the way you did your job for the employer. And sometimes, again, the wording change. Sometimes it is an own occupation. They'll call it own occupation, and it actually will say that we will look at the way you did your job for your employer. Sometimes it's called a regular occupation definition of disability. So just let us reemphasize that it's important to read and understand that definition of disability, because they can change. It depends how it's worded. They're not always clear. Sometimes they can be ambiguous. And if you are not entirely sure about what your definition of disability means, how it protects you, that's a good time to get a lawyer involved and to get some advice and some help to make sure that your rights are being protected.
And I just want to add one other important aspect of the material duties is that there's kind of two sides to it. There's the physical duties, which goes into, how often do you have to stand? How often do you have to walk during the workday? How long do you have to sit during the workday? Do you have to lift a certain amount of weight typically during the workday? But there's also the cognitive duties, and so that'll more address, what kind of tasks are you actually performing? What are the complexity of those tasks? How efficient do you have to be? How much concentration do you have to put into your task? Those types of things. So you want to make sure you're thinking about both the physical and the cognitive.
Right, and a lot of time we see insurance companies just focusing on the physical aspects of a job. So if you have a job that's, let's say you're an accountant, and it's really important that you're accurate and you have good attention to detail, the insurance company's file reviewers and their vocational personnel might just say, well, you can lift 10 pounds, you can sit for a period of time, but they don't pay any attention to the fact that you have serious pain. You might have serious pain, and that pain could impact your ability to focus into your job, or that you're not sleeping well, and the fatigue could impact your ability to do the job. So it's really important to ensure that the insurance company is considering all of the aspects of your job, physical and cognitive, and it's the burden is on you to provide that evidence. You can't rely on the insurance company to make their claim for you. You need to get that together. I know when we're representing clients, in addition to working with the treating doctors, getting experts involved to quantify the impairments, we also sometimes work with vocational experts. And the vocational experts, their expertise is in taking the impairments that are medically established by our treatment providers and by experts, and lining those up with the duties or what is required to do either your own occupation or another occupation, depending on the applicable definition. And that can be really helpful, and sometimes it's absolutely necessary, particularly where the insurance company has denied your benefits using vocational expert opinions. You want to rebut that. You don't want to let insurance company expert opinions go unresponded to. So it's that's something that we often do for our clients, and it's something you want to evaluate for and make sure you're covering.
Right. And if you're handling your claim on your own, there's still things you can do to kind of think about and come up with what the material duties of your own occupation would be. A good place often to start is with, if your company provides a job description for your position, that's a good place to start. Like we said, typically the own occupation is as it's performed in the national economy, so that might not be completely accurate in terms of your LTD coverage, but it's a good place to start. And it's also useful just for you to sit down and just think about, what do I have to do physically on a day-to-day basis at work? What do I have to do cognitively on a day-to-day basis? And just write those out as well. Yeah,
it's a great exercise to put things in writing, or work with a family member and put things in writing for yourself. Outline what is going on with yourself so you have it in black and white in front of you. And it starts by, when people are thinking about their disability claim, they're thinking about what is wrong with their health. And so start with your symptoms. What are you suffering with? List those out for yourself. Then think about what it takes to do your job and how those symptoms impact your ability to do your job. And just having that in front of you will guide what your next steps are, or should help guide what your next steps are with respect to your claim. And if you're in a situation where you're saying, look, I'm suffering from a symptom, this symptom impacts my ability to do my job, but maybe I don't have good medical testing proving that symptom exists, that might be a good time to talk to your doctors about that, to get a lawyer involved to help you quantify what you're experiencing. And with those quantified symptoms, you'll be able to explain better why you're not able to do your own occupation. I think, anything more on own occupation, or should we move on to talking about any OC?
So one thing I would just add is that there are certain things that are usually a duty of almost any job out there, but a lot of times people don't always think of them as a material duty. And some examples are those that you need to be able to show up to work reliably and consistently. You need to be able to, usually for most jobs, show up at a set time each day. You need to perform your work, efficiently while you're there. And so those will likely apply to any job, but that's something the insurance companies especially often don't take into consideration. So if you have, for example, like sleep issues that impact your ability to get a good night's sleep, and that impacts your ability to get up in the morning and get to work, that can negatively impact your ability to do your job, but often that won't be taken into consideration. So those are just things to keep in mind as well.
That's a great point. And even if you can do your job 1 day a week, 2 days a week, but you can't do it 5 days a week, week after week, reliably and consistently, you might be disabled. And so you think about it in that context. And it might be a helpful exercise for you to think about yourself as your employer. And if you were your own supervisor, looking at what you're able to do and not do, are they satisfied with your work? Are you employable in that position given your limitations and your unreliability doing that? It's a tough analysis to do because it can be heartbreaking to really cope with the realization that you're not able to do what you did before, but it's an important part of the process. And that's what we do with our clients. We try to take them through a reflective process where we take a realistic approach or a realistic view of their situation and line it up with their claim. So just good things to think about, and that was a great point. So let's move to any occupation. And so this is where the rubber hits the road for a lot of claim denials, and probably the most claim denials we get are people who have received letters from insurance companies saying you can do another job.
Right.
And so let's tell our viewers a little bit about the any occupation definition of disability.
Sure. So when the own occupation, as we said, was looking at whether you could perform the material duties of your own job, the job you were doing when you become disabled. When it switches to the any occupation, if your policy has that definition, it's now asking whether you're able to perform the material duties of any job. And some policies, it's a very broad definition. It literally is, can you perform any other job? And that's it. And if you can't show that you're disabled essentially from performing almost all jobs, then they're going to say you're no longer entitled to benefits. But typically, but not all, policies will ask whether you're capable of doing any other gainful occupation. And that takes into consideration what you were earning before you became disabled, and it asks whether you're able to perform the duties of another job that will earn you a certain percentage of your pre-disability earnings. Is typically how it's framed. And that can become important, especially if you were a very high earner before you became disabled. The insurance company is going to need to show that you can do a job that'll earn you, usually it's about 60%, sometimes 80% of your prior salary, which can be a high burden to meet depending on what your prior job was.
And with many policies, maybe most policies, the insurance company doesn't have to find you another job.
Right.
They don't have to prove that there's another available job. And in some areas of the law, sometimes in workers' compensation and other areas, there's a burden on the insurance company to prove that there's other employment available to you that you could do. Not so with respect to most long-term disability policies. The burden is on you to prove you are disabled, but there is not a burden on the insurance company to find you that job or to respond to that in that way. So just be careful. We hear that a lot from people, right, that who's going to hire me? I mean, here's what's wrong with me. Who's going to hire me? They can't find me another job. Right. And they don't have to. They don't have to. And it's counterintuitive, but it's the unfortunate reality. With both own occupation and any occupation definitions of disability, something that's often overlooked are the number of doctor appointments that a person has to attend. And so when we're talking to clients about their symptoms and their job duties, or their symptoms and how they prevent them from doing any job, we always like to ask, well, how many doctor appointments do you go to? And we collect the medical records as part of our process, and we actually will quantify, we'll add them up, and we'll say, look, this is how many days you would have missed just going to doctor appointments. And many times doctor appointments have to be during business hours, which are hours when you're expected to be attending work. And if you're already missing 3 weeks of work a year due to doctor appointments, on top of sick visits and other things, that alone could be enough to render you disabled. Usually not. Usually there's more to it, but it's an important element to consider, and one factor among all the factors that should be considered and argued, frankly, in a long-term disability appeal.
So one other aspect of the any occupation definition that we didn't talk about yet, in addition to the gainful component as we usually talk about it, is that a lot of the definitions for any occupation, definition disability, will also say that you have to be disabled whether you can perform any occupation that you are reasonably able to perform given your training, education, experience, and sometimes age. Again, these definitions vary policy to policy, but a lot of times the insurance company does have to take into account, what your education level is, what your prior work history is, when they're determining whether you'd actually be able to perform that other job.
And they often use vocational experts of their own. So a lot of times the insurance companies will employ vocational experts, or they will hire them as outside contractors to review the files, to look at your history, and to make the case that you should be able to work on a job. And if your denial is based on that, or vocational factors like that, it's important to identify that and rebut that with good, credible evidence. And usually that's engaging a vocational expert to review the report. And for our clients, we get the claim file, we review the claim file, we look at the reports, and we'll identify what in those reports, if there is an error, needs to be responded to. And we have our experts review them and analyze them and respond to those. And it's critically important, particularly if you're in the appeal process, to do this, because if you get a final appeal denial, the record usually closes at that point. And so typically you cannot get substantive evidence into the record without, after the final claim denial. There was actually a recent decision out of the First Circuit Court of Appeals where an administrator, an insurance company, by agreement, agreed to consider evidence after a final appeal denial. They essentially reopened the administrative record. It's a rare exception that happens in our experience. And so just to reinforce that, your appeal is usually the last time you'll have to get medical evidence, to get expert evidence into the record before court. And by the time you're in court, you're probably restricted, or the judge will be restricted to looking at what is in the evidence record developed during the appeal. So the appeal is the critical time, and it's usually the time to get a lawyer involved. Anything more on any occupation definitions of disability, Leah?
I think we covered it. I think, as we've been saying, you just have to read it because all definitions are different, and there could be different aspects going into it that you need to consider. So just read your policy.
There was one thing that occurred to me on the own occupation definition of disability that people may find interesting, which is the issue of specialties. And if you buy a policy that has an own occupation definition of disability, and you're a doctor or a lawyer, for example, there is a question as to what is covered. And so let's say you're a surgeon and you have a long-term disability policy, and you develop a condition that causes you to lose feeling in your fingertips. And so you can't perform surgeries, but you still are cognitively able to practice. You could see patients in the office, you could teach, you could do other things using your medical license, but you can't do surgeries. Are you covered? Are you disabled? Are you entitled to benefits under your policy? The answer, it depends. It depends on how your policy is worded. And some policies will say you are protected and that you are disabled if you cannot perform surgeries. And so they'll look at your specialty, maybe they look at your board certification. Sometimes they will do an analysis to see what aspects of medicine or what your practice involved prior to practice to your disability. So they'll look at your CPT codes, your billing codes, to see what services you were rendering in the months leading up to your disability, and they'll use that to define it. Others will take the position that the definition of disability, your own occupation is as broad as your license. And if that's the case, maybe you can't perform surgeries anymore, but if you could see patients in office, perhaps you're not disabled. You really need to scrutinize the policy carefully. If you're in one of these situations, you sense you might be facing a denial on this grounds, you should get a lawyer involved, get some expert advice on what coverage you have and what things you should be doing to look out for that. So another thing another question or frustration that we hear from our clients or potential clients is, look, I'm getting Social Security benefits. The federal government says I'm disabled, but the insurance company says I'm not. And how could they deny me if I'm getting Social Security? And there can be a lot of answers to that. But one thing that insurance companies will typically write is that we have different standards in evaluating disability. And so could you talk a little bit about the Social Security definition of disability and how it compares to that which is in long-term disability policies?
Sure. So the Social Security standard is typically whether you're able to engage in any substantial gainful activity. And there's typically an earnings threshold that goes along with that. Effectively, it's like an any occupation definition of disability, but the Social Security definition is typically harder to meet than most own occupation definitions of disability in the policy. So,
it's harder to meet because it's whether, just to underscore that, own occupations, whether you can do your own job, whether it's for your employer or the national economy. Social Security it's effectively whether you can do any job that would pay you a gainful wage.
Right. And so you might be disabled from your own occupation, but that doesn't necessarily mean you're going to be disabled under the Social Security rules.
And then even where your long-term disability claim is governed by the any occupation definition of disability, sometimes it still can be different than the Social Security definition of disability, because sometimes the any occupation definition of disability in your long-term disability policy doesn't take your age into account. The Social Security Administration will, and they'll take it into account in deciding whether there's other alternative work you can do. And if you're, depends on the claim, but if you're in your 50s or 60s, you're disabled, the Social Security Administration will consider whether you have the ability to transfer to another job. Not all long-term disability policies provide for that. So there's a whole host of different distinctions there. And just to underscore it, you need to read your policy, you need to understand your policy, to understand what the terms are, so that you're not operating under any false assumptions that your long-term disability policy provides coverage like Social Security, because there's often differences in how they handle them. So I think, do you have anything else to add, Leah, for our viewers?
I think, just to reiterate, as you just said, start with reading your policy and read it cover to cover, because there's lots of critical information in there. But a big important piece of that is reading your definition of disability and understanding what definition applies to your claim. In addition to that, you want to understand how your policy is written to know if your definition is going to change over time. Does it start with own occupation and then change to any occupation after a certain period of time? Is it own occupation the entire time? Those are important things to know. Typically, as we said, it usually starts with own occupation, and then after typically 24 months, it'll then change to the any occupation. If your claim was wrongly denied, or you're struggling to understand the definition of disability as it's written in your policy, that's the time to get long-term disability lawyers like us involved, so we can assist with that, because helping people get the long-term disability benefits they're wrongly denied is a big part of our practice.
Great. Thanks, Leah. Well, I think that's all we have for today on definitions of disability. There are more facets to this issue. We've just tried to give you an overview to hopefully get you on a solid footing for your journey, whether you're going to try to read and understand it yourself or talk to lawyers, so you'll be better informed to have that conversation as you're figuring out what your next steps are with respect to your claim. If you're struggling with making a claim or a claim denial, please feel free to reach out to us, and we help people with these types of claims, and we'd be happy to talk to you about whether we're able to assist you. And don't forget to like us on Facebook so that you get future updates about other Facebook Lives that we'll be doing. Thank you all very much.